In one of the most anticipated opinions of this Supreme Court term, Trump versus Barbara questions whether an executive order with the language that mirrors the Constitution is actually constitutional. I believe that history will remember this opinion as one of the dumbest of any Supreme Court in history. So we'll take a look at this next in the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. Glad you could join me today. In the history of the Supreme Court, Roe v. Wade, Dred Scott, and now United States v. Barbara, these should go down in history as some of the dumbest decisions made by the Supreme Court. A perfect example why courts do not make law. They offer opinions, and they often get it wrong. Now, if you want to follow along, you want to see all the links and my sources, well, head to the website constitutionstudy.com and find this article. Double check my work. Read over what the opinion. See if I've got it right or not. I'll talk more about the website and what you can do over there at the end of the episode. But for now, let's get into this question of birthright citizenship. While birthright citizenship has been a very hot topic over the last several years, one question seems to have boiled to the top. The question presented is whether the Constitution guarantees citizenship to children born in the United States of parents who are unlawfully or temporarily present in the country. The question revolves around the language of the first section of the 14th Amendment, which reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Specifically, what do the words "and subject to the jurisdiction thereof" mean? On January 20th, 2025, President Trump issued Executive Order number 14160 titled Protecting the Meaning and Value of American Citizenship. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, which uses the same language. What seems lost in most of the debate around this executive order is the fact that it mirrors the language of federal law, which mirrors the language of the 14th Amendment, specifically, and subject to the jurisdiction thereof. Yet, that did not stop people from filing suit. Several plaintiffs filed suit, some in the name of their children, arguing that the executive order violates the 14th Amendment and the INA. The district court agreed, provisionally certifying a nationwide class of children who would be denied citizenship by the order and preliminary enjoin the order's enforcement. This court granted certiorari before judgment. Okay, problem number one. How can an executive order that uses the same language as the Immigration and Nationality Act and the 14th Amendment violate both of them? The citizenship clause must be understood in light of its historical context, from the English common law to the widespread condemnation of the court's decision in Dred Scott v. Sanford. Does anyone else find it ironic that Chief Justice Roberts is using English common law to justify a decision about the American Constitution on the 250th anniversary of the publication of the Declaration of Independence? I thought we declared independence from, among other things, rule by judges. After all, that is what English common law is. The ancient law of England based on societal customs and recognized and enforced by the judgments and decrees of the courts. The general body of statutes and case law that governed England and the American colonies prior to the American Revolution. This common law citizenship, known as jus soli, or right of the soil, crossed the Atlantic and prevailed in each and all of the states after American independence. Now, Justice Thomas deals with this more in his dissent, so I'll wait until we get there before I dig in. Before we get there, though, we need to understand why Congress passed the Civil Rights Act of 1866 and proposed what became the 14th Amendment to the states. In Dred Scott v. Sanford, the court departed from the common law and adopted the view that blood, not soil, determined citizenship. It held that those descended from slaves could not be citizens. The decision was met with shock. Specifically, the Supreme Court in the Dred Scott v. Sanford case stated, when the Constitution was adopted, they were not regarding any of the states as members of the community which constituted the state and were not numbered among its people or citizens. Consequently, the special rights and immunities guaranteed to citizens do not apply to them, and not being citizens within the meaning of the Constitution, they are not entitled to sue in that character in a court of the United States, and the circuit court has not jurisdiction in such a suit. Because slaves were not treated as people, SCOTUS said they were not citizens and therefore not guaranteed the rights and immunities of such. No wonder the decision was such a shock. But once again, we see SCOTUS rewriting history for their own benefit. The 14th Amendment Citizenship Clause mirrored the common law's criteria for citizenship, starting with territory, a child must be born in the United States, and ending with a sovereign power, a child must be subject to the jurisdiction of the United States. Except the 14th Amendment does not mirror the common law criteria for citizenship. It adds a very important condition, and subject to the jurisdiction thereof. But what does that mean? A child born on American soil and subject to the American law was made an American citizen. The Citizenship Clause's key phrase, subject to the jurisdiction, refers to the power of the United States to govern those within its territory. Again, the 14th Amendment does not say, and subject to the laws of the United States. Everyone within the territory of any country is subject to their laws. As Senator Howard stated on the floor of the Senate, this amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of person. The plain intent of Congress, specifically the man who proposed the language and subject to the jurisdiction thereof, was that foreigners and aliens, along with families of foreign ministers, would not be included as citizens of the United States, which leads us to a previous SCOTUS case about birthright citizenship. The court's precedent in United States versus Wong Kim Ark confirms this rule, except the court's precedent blatantly violated the language of the Citizenship Clause. A child born in the United States of parents of Chinese descent who, at the time of his birth, are subject of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business and not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. Now, how can a child of parents who, at the time of his birth, were subjects of the Emperor of China be subject to the United States? Yes, they had permanent residency status, but that also points to John Roberts' mistake. In Wong Kim Ark, the court held that the 14th Amendment was declaratory of the fundamental rule of citizenship by birth that prevailed at common law. See, U.S. v. Ark did not confirm the English common law standard. Rather, it conflated legal residency with subject to the jurisdiction thereof. Next, let's take a look at Justice Kavanaugh's opinion. It's referred to as an opinion since he concurs in part and dissents in part. Executive Order 14160 establishes new exemptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country. The court today holds that the order violates the 14th Amendment to the Constitution. I respectfully disagree with the court's constitutional holding. Except Trump's executive order does not establish new exceptions to birthright citizenship. It's an attempt to restore the plain language and the obvious congressional intent behind the words and subject to the jurisdiction thereof in both the 14th Amendment and federal law. Initially enacted in 1940, Section 1401A of Title VIII provides that persons born in the United States and subject to the jurisdiction thereof shall be nationals and citizens of the United States at birth. Justice Kavanaugh points out that the Supreme Court in the Ark case created 4 distinct exceptions for citizenship, none of which appear in the language of the 14th Amendment, and only one of which appears in the congressional record in regard to the language and subject to the jurisdiction thereof. In other words, SCOTUS and the Wong Kim Ark case decided to rewrite the law, apparently to get the outcome the majority wanted. And here, they do the same. In 2025, however, Executive Order number 14160 sought to add 2 new exceptions to birthright citizenship for children born to foreign citizens who are either illegally or temporarily in the United States. In doing so, the Executive Order goes beyond what Section 1401A authorizes. For the Executive Order to be lawful, therefore, Congress would need to amend 1401A or otherwise enact new legislation to encompass those 2 new exceptions. Again, Executive Order 14160 does not add new exceptions. The EO literally mirrors the language of both federal law and the Constitution. The very idea that someone visiting the United States or has entered this country illegally is subject to our jurisdiction will, I think, go down in history as one of the greatest examples of judicial overreach and hubris. Now, Justice Thomas wrote a lengthy dissent, totaling 90 pages. While the size doesn't make right, here I summarize what I think are the best arguments. The court decision in Dred Scott v. Sanford would have permanently denied citizenship to blacks as a subordinate and inferior class. After the Civil War, the Reconstruction Congress overruled Dred Scott, first with the Civil Rights Act of 1866, then with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guarantee citizenship to persons born and domiciled in the United States, regardless of their race. Neither guaranteed citizenship to persons who were not domiciled in the United States. There's that word domicile again. I find this interesting for two reasons. First, the word domicile does not exist in either the text of the 14th Amendment or Senator Howard's explanation of the language and subject to the jurisdiction thereof. Second, because I see Justice Thomas's point when it comes to post-Civil War blacks. They were not citizens according to the courts, but they were permanent residents of the United States. Blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. This is a completely different situation from children of visitors or illegal aliens. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in a time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. A person was a citizen of the state where he had his domicile. When foreigners temporarily visited, their national character was unchanged. Such visitors were strangers, not subjects. A person born here but domiciled in a foreign land was therefore considered as much a stranger to the country as his father. Now, visitors do not live in the United States. They're visiting. And people who enter this country illegally do not have a legal domicile in the United States. So to be a citizen at birth, the child, or more accurately the parents, need to be subject to the United States, meaning someone with a duty to this country, or as Justice Thomas put it, could be called upon in a time of war. This was obviously Congress's intent in both the Civil Rights Act of 1866 and the Citizenship Clause of the 14th Amendment. Congress implemented the principles that citizenship follows birth and domicile in the Civil Rights Act of 1866 and then in the Citizenship Clause of the 14th Amendment. The Civil Rights Act guaranteed citizenship to persons who were both born in the United States and, as relevant here, not subject to any foreign power. The phrase not subject to any foreign power excluded from citizenship children of foreign temporary visitors who were subject to the power of their home nation. The Citizenship Clause, which the same Congress passed shortly after the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdiction over persons. So the clear intent of Congress is that not only someone be born in the United States to obtain citizenship, but that they have some legal relationship here as well. At the very least, that they are not subject to a foreign power. But that's not what this court said in its opinion. The court offers a different account. American citizenship, the court says, was based on medieval English feudal principles, according to which each person owed personal service to the lord of the soil as his master, a perpetual servitude that was born with the child and only ended in the grave. Americans, the court says, adopted this feudal principle as a rule of American citizenship with little fanfare. Then, according to the court, the Reconstruction Congress codified the feudal principle with the words not subject to any foreign power in the Civil Rights Act and subject to the jurisdiction thereof in the Citizenship Clause. Then, the court says the clause meaning was definitively settled by dicta United States v. Wong Kim Ark. Again, the court claims its interpretation, its opinion about the case, defines what the Constitution means. Their elevation of medieval English principles above the supreme law of the land, the law they took an oath to support, proves the bad behavior of so many of these justices. I guess they never learned in law school that they are a creation of the Constitution, not its master, which may explain Justice Thomas's conclusion. Now, as Justice Alito points out in his dissent, every step of this story is incorrect. The Declaration of Independence repudiated the foundation on which the British rule was based. From 1776 until the eve of the Civil War, the status of the rule in the country was unsettled. There is no evidence establishing that the Constitution's reference to citizens incorporated the British rule. And until the eve of the Civil War, there was little litigation about the meaning of American citizenship. Now, after the war, Congress finally adopted a constitutional provision, Section 1 of the 14th Amendment, making certain persons citizens at birth, but that provision differed substantially from the British rule. It specified that a person born here is not a citizen unless his allegiance to the United States is unimpaired by any obligation to a foreign power. Justice Thomas concludes, the court today takes the extraordinary step of holding facially unconstitutional the President's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the President's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent. Now, speaking of Justice Alito, his dissent deals with one of the arguments against both the plain language and constitutional intent behind the 14th Amendment. This is one of the most important decisions in the history of the court, and in my judgment, the court has made a serious mistake. As interpreted by the court today, the 14th Amendment confers citizenship on virtually everyone who happened to be born in this country, including children of birth tourists, women who come here solely for the purpose of giving birth to a child and then promptly return home. Now, based on the court's opinion, the words "and subject to the jurisdiction thereof" are all but meaningless. If you were born here, there needs to be no legal tie to the United States to be considered a citizen of this court. The fact that this completely ignores the Constitution proves once again that the 9 people most in need of a reading comprehension program are the justices of the Supreme Court. Careful analysis of the text of the 14th Amendment and the process that led to its adoption shows that it does not degrade the concept of United States citizenship in this way. Instead, the 14th Amendment confers citizenship only on those children who, at birth, owe allegiance solely to this country. The question Alito delves into is, what about those who have been given citizenship under this erroneous understanding of the English language? Respecting this interpretation would not require uprooting millions of children who are born to mothers who entered or remained in this country illegally. Those children are not responsible for their parents' violation of our immigration laws, and their plight is the result of a long period during which a coterie of actors, executive branch officials, states and cities, and a variety of private groups sent the message to would-be immigrants that our immigration laws should not be taken too seriously. This message, coupled with ineffective or unenthusiastic enforcement, spurred massive illegal immigration and the growth of a large contingent of people who were born here to mothers unlawfully present in this country. Now, some members of the group have lived here for years, and they have a strong moral claim to be able to remain in the land where they grew up. Children often suffer the consequences of their parents' decisions. However, Justice Alito believes that just because parents and a coterie of government actors broke the law doesn't mean that children should be punished. For these reasons, the original meaning of the 14th Amendment does not require inhumane results, and we should not adopt an erroneous interpretation of the 14th Amendment simply out of a fear of the consequences of rocking the boat or a reaction to current immigration policy. Now, based on all of this, I hope you'll agree that this decision may be one of the dumbest in the court's history. Held, children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment Citizenship Clause. How is an illegal alien subject to the jurisdiction of the United States? Remember, when Justice Roberts wrote in his decision, a child born on American soil and subject to American law was made an American citizen, he simply wrote into the Constitution a limitation that does not exist in the 14th Amendment or congressional intent. In other words, the court just made this up, rather like they did in the Wong Kim Ark case. Speaking of that case, Justice Roberts also wrote, attempts to narrow Wong Kim Ark by noting that the court's opinion repeatedly referred to the domicile of Wong's parents failed because the holding's underlying reasoning cannot be squared with a domicile requirement. The Ark court, which focused on the legal residency of Mr. Ark's parents, doesn't get Justice Thomas where he wants to go. That's the only reason I can think of simply ignoring the law and judicial precedent. Now, do you see why I say this may be the dumbest decision in the court's history? They ignored the Constitution, federal law, and their own precedent to come up with an irrational decision that not only destroys the very idea of citizenship, but the rule of law as well. After all, what good are laws if courts are going to simply ignore them when they're inconvenient to the court's agenda? That's why I say this decision, United States v. Barber, is going to rank right up there with Dred Scott and Roe v. Wade. It's dumb. It's judicial hubris. It's simply making up the law and ignoring the actual language that's there. Sadly, that's not that uncommon. It's just this is one of the most blatant examples I've seen in a long, long time. But what do? Well, first of all, states need to recognize that that's a decision of the court. They got it wrong. Remember, the states created the Supreme Court, not the other way around. The states can simply say, no, Supreme Court, you're wrong. When we ratified the 14th Amendment, we meant you need to be subject to our jurisdiction. I'd love to see them answer the question about domicile, though, because domicile is not the same as subject. I can domicile in one state and still be a subject in another state. So, yeah, it's interesting. In other words, I can domicile here in the United States, but still be a citizen and therefore subject to the Great Britain, United Kingdom, France, Spain, wherever. So again, dumb. And, Thomas was very verbose in his response, but he made some really, really good points. Although, again, I still question that domicile requirement because domicile is not the same as subject to the jurisdiction. So what do you think? Do you think I got it right? Do you think I got it completely wrong? I'd love to hear what you have to say. You can find out more at the website, constitutionstudy.com. Find this article and leave a comment. Find me on social media, YouTube, Rumble, X. I'm even on Locals. Comment there as well. But remember, the reason I go through these cases is so that you understand the constitutional issues behind them, so you can begin to rectify them, whether it's by Congress, which is already working on some stuff to deal with some of this, or our states. Now, I hope you like the work that we're doing here, and I hope you're willing to support the work that we're doing here. You can do so at constitutionstudy.com/shop by buying a book or a t-shirt or a mug, or hey, just donate to the cause. All of it's available there, and all the proceeds go to keeping this program up and running. Nobody here takes a salary. Nobody here gets funding from it. We volunteer and we fund all the work that we're doing here, with the exception of a few generous donors, hopefully soon to be joined by you. Of course, you can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. I joined them several years ago because they take a portion of every dollar they make to support organizations like the Constitution Study that are protecting your rights, defending your rights, and helping you learn to do so yourself. So when you go to patriotmobile.com/constitution and you find a plan that works for you, when you pay your cell phone bill, you're helping support the work that we're doing here at the Constitution Study. Use the code Constitution at checkout, you'll get free activation. And check to see if you're eligible for a discount. I mean, yes, Patriot Mobile has some great prices, but there are discounts for families with multiple lines, NRA members, veterans, first responders. Just go to patriotmobile.com/constitution, find out more. Find the plan that works for you, find the discount that works for you. When you check out, use that code Constitution for free activation. I hope you enjoy the work that we're doing here. I hope you're ready because there's a lot of SCOTUS stuff coming up. We just went through their silly season. So I hope you'll come back next time and maybe bring a friend or two when we get together for the Constitution Study.
Love the neighbors and have a few good